Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi everyone, this is Stephanie with Michigan Condo Voices. If your Michigan HOA or condo association takes you to court, you are immediately placed on a dangerous, fast-moving clock. A lot of homeowners assume that if a lawsuit is unfair or completely frivolous, they can just ignore it until it blows over. That is a critical mistake. Under Michigan Court Rule 2.108, once you are formally served with a summons and complaint in a Michigan court, you generally have exactly 21 days to file a written answer. If you were served by mail or outside the state, you get a whopping 28 days to respond. What happens if you miss that deadline? The association's lawyer will immediately file for a default, and many associations count on this. Once a default is entered, you legally lose your right to defend yourself in the case. The court then issues a default judgment, meaning the HOA automatically wins everything they ask for. This isn't just a piece of paper. A default judgment gives the association immediate legal power to execute certain things like garnish your wages, place a lien on your property, or in severe cases, initiate a foreclosure to force the sale of your home. To understand how an HOA lawsuit works, you have to ask one fundamental question. Who is paying for the lawyer suing you? The answer is simple. You are. Your regular monthly or annual assessments fund the association's operating budget. That budget pays for landscaping, insurance, management, and yes, professional legal expenses. In almost every community, lawsuits are initially funded straight out of the shared association resources. Now, this doesn't mean every lawsuit filed by an association is automatically improper. Board members have a fiduciary duty to protect the community. There are perfectly legitimate reasons for an association to take legal action, such as enforcing governing documents, collecting severely delinquent assessments, protecting common areas, or pursuing necessary construction defect remedies. But what you must understand are the financial mechanics behind it. When an HOA sues a homeowner, they are actively spending community assets, money collected from you and your neighbors to fund their legal counsel. There is a massive difference between what an association spends on a lawsuit, what they recover, and what is ultimately charged to your specific ledger. If you live in a co-owner community, you need to know about Section 106 of the Michigan Condominium Act. Under this law, if the condominium documents explicitly allow for it, a winning association can recover its reasonable attorney fees and court costs from the defaulting co-owner. This creates what defense attorneys call the snowball effect. A dispute might start over a relatively small issue, like an unapproved deck modification or $500 in missed dues. But the moment the association involves a corporate law firm, the clock starts running at hundreds of dollars per hour. If the case goes to court and the association wins, that initial $500 issue can easily snowball into $10,000, $15,000, or $20,000 in mandatory legal fees, all legally shifted directly onto your shoulders. If you cannot pay those shifted legal fees, the association can attach them directly to your unit as a lien and proceed with a foreclosure action. But what happens if the script is flipped? What if a homeowner decides to bring a lawsuit or a counterclaim against the association or board? This is where the financial picture gets complicated and where directors and officers or D&O insurance may enter the chat. D&O insurance is designed to provide financial defense protection for board members when they are sued for actions, errors, omissions, or governance decisions made in the course of running the community. It protects volunteers from being held personally liable for a bad business decision or an alleged breach of fiduciary duty. However, homeowners frequently misunderstand how D&O insurance works in two major ways. First, D&O insurance cannot be used as a weapon to initiate a lawsuit. An HOA board cannot use the insurance policy to fund an offensive legal attack against an owner. It is strictly a defensive shield. Second, coverage is never automatic. Whether an insurance company takes over, the defense depends entirely on the specific allegations, policy limits, deductibles, and explicit exclusions. For example, D&O insurance almost universally excludes coverage for intentional fraud, self-dealing, criminal acts, or willful violations of the law. If a homeowner brings a counterclaim, do not assume an insurance company is picking up the tab. The actual policy limits and corporate circumstances matter immensely. Why should you care about these legal mechanics if you are not currently being sued? Because litigation is not just a legal issue, it is a community-wide financial issue. Every dollar spent on an aggressive lawsuit or a prolonged legal battle is a dollar taken away from your property reserves, roof replacements, road repaving, and property values. As a homeowner in Michigan, you have a legal right to review the financial records of your association. When you are reviewing those annual audits or financial statements, these are 5 financial literacy questions you should be asking. What specific type of legal expenses is our association incurring? Are they collection matters, rule enforcement actions, or internal governance disputes? Are these legal expenses being paid directly out of our standard operating fund, or are they draining our emergency reserves? What percentage of our spent legal fees were actually recovered and brought back into the community bank accounts? Were any specific legal costs charged back directly to individual homeowners' ledgers? And did our D&O insurance kick in to cover our defense costs, or are we paying out of pocket for a deductible or an uncovered claim? Asking these questions isn't about throwing accusations or starting a fight with your board. It is about understanding how your community's shared financial resources are being managed. Now let's summarize the ultimate takeaway. If you ever receive a legal summons or a formal violation warning from your HOA or condo association, do not lose time focusing entirely on whether the board is right or wrong. First, focus entirely on the process. Read the documents immediately. Know your exact Michigan response deadline, whether it is 21 or 28 days. Never ignore a lawsuit and consult a qualified independent real estate attorney who specializes in Michigan Community Association law to protect your rights. At the exact same time, look at the big picture. As a homeowner, you have a legitimate vested interest in tracking how litigation impacts the financial health of your neighborhood. Because when you follow the money, you quickly learn exactly how your association operates behind closed doors. This isn't about being for or against HOAs. It is about understanding the system you bought into. And sometimes the best place to start is with one simple question: who is paying for this? This is Michigan Condo Voices. You are always welcome here. Thanks for listening, everyone. Take care.